Hello, legal minds. Welcome to Law Tutorials. I'm very happy to be one of your tutorial masters and, of course, very excited to present the first lesson on this platform. Law Tutorials was created to demystify difficult law concepts by simplifying them with hypothetical and real-life practical examples for better understanding, especially as law is more of practical than theoretical, and to answer law questions. Our first lesson is a summary of what the law is all about. Assuming we have first year students and final year students, including non-legal minds who are interested in understanding and knowing the law, we have decided to start with an introductory class so as to enable everybody to be able to relate well with the law and to follow up very well on subsequent law lessons. Remember, all you need to do is to subscribe to our YouTube channel and follow our Facebook page in order to have full access to all of our uploaded law lessons so that you'll be able to watch and learn at any time convenient to you. So without wasting much of your time, let's get down to our lesson for today. Understanding the law, part 1. First point is introduction. Now, law is commonly understood as a system of rules that are created and enforced through social or governmental institutions to regulate conduct, even though its precise definition is a matter of long-standing debate. It has been variously described as a science and the art of justice. The formation of laws may be influenced by a constitution which can either be written or tacit, and the rights encoded therein. The law shapes politics, economics, history, and society in various ways and serves as a mediator of relations between people. Now, scope can be divided into two major domains: public law, which concerns government and society, including constitutional law, administrative law, and criminal law, and private law, which deals with legal dispute between individuals and organizations in areas such as contract, property, tort or delict, and commercial law. Law provides a source of scholarly inquiry into legal history, philosophy, economic analysis, and sociology, as well as raises important and complex issues concerning equality, fairness, and justice. Now, let's look at the philosophy of law. Now, the philosophy of law is commonly known as jurisprudence. Normative jurisprudence asks, what should law be? While analytic jurisprudence asks what law is. That is, what is law? Now, John Austin's utilitarian answer was that law is commands backed by threat of sanctions from a sovereign to whom people have a habit of obedience. Natural lawyers, on the other hand, such as Jean-Jacques Rousseau, argued that law reflects essentially moral and unchangeable laws of nature. Now, Hugo Grotius, the founder of a purely rationalistic system of natural law, argued that law arises from both a social impulse and reason. Immanuel Kant believed a moral imperative requires laws be chosen as though they should hold as universal laws of nature. Jeremy Bentham and his student Austin, following David Hume, believed that these conflicted the is and what ought to be problem. Now, Bentham and Austin argued for law's positivism, that real law is entirely separate from morality. Kant was also criticized by Friedrich Nietzsche, who rejected the principle of equality and believed that law emanates from the will to power and cannot be labeled as moral or immoral. In 1934, Hans Kelsen continued the positivist tradition in his book titled The Pure Theory of Law. Kelsen believed that although law is separate from morality, it is endowed with normativity, meaning we ought to obey it. While laws are positive is statements, for example, the fine for reversing on a highway is 500 US dollar. Law tells us what we should do. Thus, each legal system can be hypothesized to have a basic norm known as the ground norm, instructing us to obey it. Now, Kelsen's major opponent, called Carl Schmitt, rejected both positivism and the idea of the rule of law because he did not accept the primacy of abstract normative principles over concrete political positions and decisions. In the 20th century, Hart attacked Austin for his simplifications and Kelsen for his fictions in the concept of law. Hart argued that law is a system of rules divided into primary rules of conduct and secondary ones, rules addressed to officials to administer primary rules. Now, secondary rules are further divided into rules of adjudication, which are rules that is to resolve legal dispute, and rules of exchange, allowing laws to be varied, and the rule of recognition, allowing laws to be identified as valid. Ronald Dworkin attacked Hart and the positivists for their refusal to treat law as a moral issue. Dworkin argued that law is an interpretive concept that requires judges to find the best fitting and most just solution to a legal dispute, given their constitutional traditions. Joseph Ras, on the other hand, defended the positivist outlook and criticized Hart by arguing that law is authority, identifiable purely through social sources and without reference to moral reasoning. But the question now is, what then is law? Now, what then is law? Now, let's look at it first. There have been several attempts to produce a universally acceptable definition of law. In 1972, Baron Hamstead suggested that no such definition could be produced. Mark Kubrick and White said that the question, what is law, has no simple answer. Glanville Williams said that the meaning of the word law depends on the context in which the word is being used. For example, early customary law and municipal law were contexts where the word law had two different and irreconcilable meanings. Thomas Arnold said that it is obvious that it's impossible to define the word law, and that it is also equally obvious that the struggle to define the word should not ever be abandoned. It is possible to take the view that there is no need to define the word law. However, one definition is outstanding that is being used all over. Law is a system of rules and guidelines which are enforced through social institutions to govern behavior. System. Legal systems vary between countries, with their differences analyzed in comparative law. That is a story of legal systems of different countries. It's known as comparative law. Now, in general, legal systems can be split between civil law and common law systems. In civil law jurisdictions, a legislature or other central body codifies and consolidates the law. But in common law systems, judges make binding case law through precedent, although on occasion, case law may be overturned by a higher court or the legislature. However, there is a third type of legal system accepted by some countries without separation of church and state. This one is known as the religious law, based on scriptures. The sources that jurisdiction adopt as authoritatively binding are the defining features of any legal system. Historically, religious laws influence secular matters and is still used in some religious communities. For example, the Sharia law, based on Islamic principles, is being used as a primary legal system in several countries, including the UAE, Iran, and Saudi Arabia. And that is the end of lesson 1, part 1. Thank you for watching. Our next lesson will be lesson 1, part 2. So guys, like, comment, and share so that others can also watch and learn. And do not forget to follow us on YouTube and Facebook. And then if you have any inquiry, please, you can email us at legalminds115@gmail.com with any question, any concept that is difficult for you to understand, and anything that you want more clarification. And we're going to do a lesson on it and publish online. So guys, that's it. Thanks for watching and stay safe. Bye. See you in the next lesson.